Remember, everybody, you will own nothing and be happy, even if it means the government
will take everything you have.
Viva Fry, former Montreal litigator turned current Florida rumbler in my home office, and I'm old enough to remember that crazy old conspiracy theory, Agenda 2030, you will own nothing and be happy. Well, it looks like it's coming to reality sooner than later to a place near you called Canada. A story went viral, or I should say a tweet. An image went viral of a letter coming from the city of Richmond in British Columbia, notifying private landowners that as a result of the Supreme Court decision that recognized rights to a native tribe as relates to unceded territory, that it might impact privately held land and that you should stay tuned for more coverage. Now, the full impact of the court ruling has yet to be determined, but the city of Richmond has taken it upon themselves to send a notice that has alarmed quite a few people, as in anybody with a sense of private property and basic God-given rights. For those of you who may have missed it, from Ryan Garrettson, at Ryan Garrettson, this is insane, from the city of Richmond in Canada. Quote, if you look at the draft map attached to the briefing, your property is located within the claim area outlined in green. For those whose property is in the area outlined in black, the court has declared Aboriginal title to your property, which may compromise the status and validity of your ownership, end quote. Do you know how much unceded land there is in provinces across Canada? Do you think that this will just end here in Richmond, British Columbia? And here you have the letter from the city of Richmond. Notice to registered owner. Please take note that the recent BC Supreme Court decision in Cowichan Tribes versus Canada 2025 BCSC 1490 made some very important decisions which could negatively affect the title to your property. A briefing paper prepared by City of Richmond staff is attached for your reference. If you look at the draft map attached to the briefing, your property is located within the claim area outlined in green. For those whose property is in the area outlined in black, the court has declared Aboriginal title to your property, which may compromise the status and validity of your ownership. This was mandated without any prior notice to the landowners. The entire area outlined in green is claimed on appeal by the Cowichan First Nations. Given the serious implications of this court decision and the pending appeal, the city is hosting an informal session to be held on Tuesday, October 28, 2025 at 7 p.m. at Richmond City Hall. We hope that you can attend to learn more about this important situation. And then here you have the contact information for anyone who's interested or affected. This is going to be complicated for pretty much everybody, even those who have studied Aboriginal law in Canada. I studied Aboriginal law when I did my law degree, though I never practiced in the field. What basically happens here is a tribe sues the government on the basis that there is unceded land. We're going to get to that in a second, that there's unceded land that is currently being occupied and that they actually have title and rights to that unceded land because it wasn't ceded to the government or private interest by way of any treaty. But don't take my word for it by any means. There's a newsletter from one of the most prominent law firms in Canada, Osler, and they describe the situation as follows. Osler Indigenous Law Blog, The Longest Trial, A Big Impact. Cowichan's Aboriginal Title Victory. Following one of the longest trials in Canadian history, the Supreme Court of British Columbia, the court, released its landmark decision in Cowichan Tribes versus Canada, Attorney General 2025, holding that the historical descendants of the Cowichan people, the plaintiffs or Cowichan, have Aboriginal title over a portion of the total claim area sought at the south shore of Lulu Island in Richmond, British Columbia, the Cowichan title lands. This is the first time in Canadian history Aboriginal title has been established over lands that included fee simple private ownership, resulting in significant uncertainty for governments, fee simple landowners, and Indigenous communities with overlapping title claims. And then at the end, in the discussion section, while the court seemed to rely on the fact that the Cowichan were not seeking to displace private owners of the lands subject to the title claim, the decision now leaves the affected private landowners and governments, as well as landowners and governments across the rest of Canada where Aboriginal title is asserted, with key outstanding questions. For example, practically, to what extent can the Cowichan now influence how the fee simple lands over which they hold Aboriginal title are used? What recourse, if any, do private landowners have against the government if the court's declaration restricts their use and enjoyment of their land? What does a good faith reconciliation of fee simple ownership over Aboriginal title lands look like? Not surprisingly, the province federal government, VFPA, and Richmond have each commenced appeals on the court's decision. Other Indigenous groups, the Musqueam Indian Band and Tsawwassen First Nation, have also commenced appeals, as has the Cowichan in respect of the court's decision to recognize Aboriginal title over only a portion of the total land area the Cowichan claimed. Regardless of how these appeals are decided, we expect this case will ultimately be appealed to the Supreme Court of Canada. And just because I realize I didn't define what fee simple means in Aboriginal law, fee simple refers to the highest possible interest in land granted by the Crown, which traditionally confers ownership rights like exclusive control, use, and transfer. However, the relationship between fee simple and Aboriginal title is complex because Aboriginal title is considered a prior and senior interest that predates Crown grants, meaning fee simple interests are subject to it. This has led to legal questions about how the two forms of ownership can coexist and has raised concerns about the security of fee simple title in areas where Aboriginal title is asserted. We have all been making fun of people like that RCMP police chief at the Nova Scotia press conference as relates to the missing children, starting off with a land recognition. We are hereby on the unceded territory of X, Y, and Z. We are now seeing the impact of what actually happens when the government starts recognizing unceded territory of Aboriginals.
Good afternoon. Good afternoon. I am Corporal Carly McCann, Provincial Public Information Officer for the Nova Scotia RCMP. Thank you all for being here today. Bonjour, je suis la caporale Carly McCann, agent d'information publique pour la GRC en Nouvelle-Écosse. Merci de votre présence aujourd'hui. First, I acknowledge that we are in Mi'kma'ki, the traditional and unceded ancestral territory of the Mi'kmaq people. I also recognize that African Nova Scotians are a distinct people whose histories, legacies, and contributions have enriched that part of Mi'kma'ki known as Nova Scotia for over 400 years.
All of a sudden, what started off as something of a ridiculous virtue signaling gesture now turns into Aboriginals claiming rights over that unceded land with the help of the government, and now they win in the court, and lo and behold, what's going to happen of private ownership on these unceded lands? Nobody knows. From Juno News, who's also covering the story, homeowners warned private property may be in doubt following BC court's Indigenous ruling. Hundreds of Richmond, British Columbia homeowners have been warned their private property could be jeopardized by a recent court ruling granting Aboriginal title to the Cowichan tribes. Alex Zoltan, True North. Hundreds of Richmond, British Columbia homeowners have been warned their private property could be jeopardized by a recent court ruling granting Aboriginal title to the Cowichan tribes. The letters have raised growing fears that similar decisions could undermine land ownership across British Columbia, as several other cases involving Aboriginal title are before the courts. The ruling issued earlier this year granted, quote, dual title, end quote, ownership to hundreds of acres of private property in Richmond, a large metropolitan suburb of Vancouver and home to BC's largest and only international airport. This means certain property would be owned both privately and under Aboriginal title. Although the ruling didn't go so far as to call for the requisitioning of private property, it remains unclear what impact the dual title will have on lending, tax implications, or private property ownership generally. Now, part of me wants to believe that the city of Richmond is issuing this letter specifically and deliberately to alarm the residents so that they make something of a public issue out of this, so that it becomes newsworthy and that they can use that public pressure in the courts to cause the higher courts to undo the damage done by this lower court. Bear in mind, the BC Supreme Court is the lowest level court in British Columbia. It goes Supreme Court of British Columbia, Court of Appeals, and then Supreme Court of Canada. So part of me wants to believe that the city of Richmond is deliberately trying to antagonize or spark up fears among the general population to create political pressure, but another part of me also thinks, oh, what's going to happen in all of this if the government now has to negotiate on private property as a result of this court ruling that grants rights to unceded land? What an accidental, fortuitous, coincidental sort of benefit this would procure to the government, who now themselves might lay claim to that private land as a result of their obligations now to negotiate with Aboriginal interests. Will it lead to expropriation with compensation? Will it lead to outright expropriation by the federal government? Because after all, they've now got to claim that land so that they can now go and negotiate with those Aboriginals who were just granted title over that unceded land. And now you might actually fully appreciate the actual legal consequences of these idiot virtue signaling government officials getting up there and recognizing that they are on unceded land. And now the courts have said, well, if it's unceded, it belongs to the Aboriginals because they didn't give it to you by way of treaty. And now they have rights over other people's private property. And if it means the government's going to take your property away, by goodness, you will own nothing and you will be happy. And speaking of being happy, you know what would make me happy is if you hit the subscribe button and turned on notifications and dropped a comment in the comment section below, because it feeds the algorithm. This is what's going on in Canada, people.
Coming soon to a communist hellhole near you.
I will be following this story. I might even try to get a lawyer from Osler or another law firm to come on to explain the situation, but this is where it stands right now. Uncertainty, to say the least, but uncertainty is good for government.
We don't submit to terror. We make the terror.
And with that said, if you like my stuff, you know what to do, but most importantly, exercise, eat healthy, sunlight, talk to people in real life, and now you know your vlog. Peace out, peeps. Booyah!